The International Court of Justice is now in session. Mr. President, the Honorable Datuk Gopal Sriram, and the Honorable Judges, Mr. Lam Koh Luen and Ms. Dr. Min Zan, presiding. The Honorable Datuk Gopal Sriram is a judge of the Court of Appeal, while Mr. Lam Koh Luen is the partner of Shuk Lin and Bo. Dr. Min Zan is the senior lecturer of School of Law at the University of Multimedia. He is also the author of The Moot Problem and the Chief Judge for Memorial. The case before the court is a matter concerning certain disputes. The parties are the government of Donoval versus the government of Berganden and the government of Fudalin. The applicant and the respondent are each allocated 45 minutes to present their pleadings.
Yes.
May it please the Honorable Court. Good morning, Your Excellencies. My name is Army Bayot, co-agent for the Union of Don Valle, the applicant in this case. With me today are my co-agent, Mr. Christopher Ocampo, and our counsel, Mr. Bong Paulo Macasal. May it please the Court. Your Excellencies, the peaceful coexistence of states as sovereign equals is of such vital importance if we are to achieve international cooperation and security.
What has that got to do with the case before us? Can you get on to the case straight away, please?
Forgive me, Your Excellency. Thank you. Your Excellencies, the Union of Dono Valle has 5 major submissions. First, the Dono Valle's sovereignty was violated when Berganden used force in intervening in our internal affairs and in committing acts of aggression against us.
Who bombed the other side? Who bombed Berganden?
Your Excellency, the state of Berganden was bombed by a renegade military officer of the Union of Dono Valle without our authorization. It was not committed by the Union of Dono Valle, Your Excellency.
What are the principles of state responsibility which attribute acts of its officials, whether renegade or not, to the government state? And how would you reconcile your submission with that?
Thank you for pointing this out, Your Excellency. While we note that under Article 7 on the Articles of State Responsibility, states may be held internationally responsible for the ultra-various acts of its officers, Your Excellencies, this only results in a states incurring state responsibility to the effect that we would be obliged to give reparation or restitution. But it does not in any way make that act our act, Your Excellencies. In order for this act to be considered an act of the Union of Dono Valle itself, it must have been done with our authority and with our express intent, Your Excellencies. Your Excellencies, may I proceed with a summary of my submissions? Thank you, Your Excellencies. Our third submission, Your Excellencies, is that Dono Valle, as a sovereign co-equal of the Union of Fudalan, is entitled to the protection of our embassy and our diplomatic agent. Fudalan breached this duty when it failed to protect our embassy and our diplomatic agents. Our fourth submission, Your Excellencies, is that Dono Valle lawfully exercised criminal jurisdiction over Ms. Tabilisi, who committed crimes against our national security.
But she didn't enter your jurisdiction. You kidnapped her. You committed a criminal act in order to subject her to the laws of your country. What's your answer to that? Doesn't that immediately taint the prosecution?
We beg to disagree. We beg to differ, Your Excellency. With all due respect, Ms. Tabilisi was not abducted by the Union of Dono Valle. She was abducted by...
A rose in name is as sweet as other. Abduction, kidnapping, forcible transfer, what does it matter? She was abducted, forcibly transferred, taken away without express consent from another state's territory.
We concede, Your Excellency, that even if the taking of Ms. Tabilisi amounts to an abduction, this abduction was not committed by the Union of Dono Valle itself, Your Excellency. It was committed by private agents.
You are exempting all things. You have exempted from the acts of Colonel Pato. you are exempting from the acts of the 5 female agents, which is mentioned in the compromise as agents. So how I would be somewhat skeptical, especially of the second claim. First claim, okay, you didn't authorize, you have a trial of Pato and put him in prison, but the second claim, how can you say that it's not applicable to the state?
Thank you for pointing this out, Your Excellency. Your Excellency, these persons, the persons who took Ms. Tabilisi from the state of Fudalan, are private persons. We refer the court's attention to the case of State versus Ibrahim, Your Excellencies. In this case, the state of South Africa was held responsible for the abduction of Ibrahim from Swaziland because it was precisely the security service itself who abducted Mr. Ibrahim. Contrast this, Your Excellencies, with the case of Eichmann, where Eichmann was abducted by mere agents of the security service of Israel, Your Excellencies. And in this case, Israel was not automatically held liable to the acts of these persons.
By
were
whom?
not
By
actually,
automatically held liable by whom?
Your Excellency.
By whom was it held not to be automatically liable? That's your submission, right?
Your Excellency, allow me to clarify. By that I mean that
Did Eichmann's case ever come before us? Before this court?
Your Excellency, that case was decided municipally. However,
So how can you cite that as an example?
thank you for pointing this out, Your Excellency. Our basis for citing the case of Eichmann is Article 38, Paragraph 1, Subparagraph D, which states that the Court of International Justice may make decisions on the basis of the decisions of judicial tribunals. We note, Your Excellencies, that since this provision does not make any distinction as to international tribunals and municipal courts, both may be sources or may be evidence of what exists as international law today.
Let me clarify. I think you are citing the Israeli Supreme Court decision saying that Eichmann, the Israeli government is not liable for the agents. But that is different from international liability. No man shall be a judge in his own cause. No court should justify its own government agent abduction. So how can, apart from what the Chief Judge has said, domestic judicial decisions will only have, at best, persuasive authority on us. And is that a good ground for your submission, the Israeli Supreme Court decision, as far as the abduction is concerned?
Indeed, Your Excellencies, we agree, Your Excellencies, that the decisions of municipal tribunals have a highly persuasive effect on the Court of International Justice. The Honorable Court, of course, may make its decision based on any of the sources enumerated on Article 38 as well, Your Excellency.
But you took advantage of the kidnapping. If you didn't want, you adopted the criminal act by putting her to trial. If you wanted to dissociate yourself from the acts of your security services, you should have released her and sent her back to Foodland. Why didn't you do that?
Thank you for pointing this out, Your Excellency. May we refer the court's attention to the case of Nicholas?
No, you answer the question, please. Why didn't you do it?
Your Excellency, we did not return Ms. Tabilisi to Foodland for the express